temporary law paves the way for a more permanent form of paid leave. President Trump has spoken in positive terms about paid leave. He's already provided it to federal workers, so stay tuned. Earlier this week, the Department of Labor issued regulations about these new laws. Just late last night, they issued another round of regulations. So if it makes you feel any better, the federal government is also apparently losing some sleep, just like we all are. But let's get to the meat here of the law. If we could have the next slide, please. So, employers must provide up to 80 hours of paid sick leave to employees for certain coronavirus-related reasons. And we're going to talk about those qualifying reasons in a moment. But first, the Department of Labor just made clear last night that the new paid sick leave and the paid FMLA leave must be taken in full day increments. So this is a major clarification, and this is one way where the government has helped employers out in administrating these laws. According to the Department of Labor, once the employee begins taking paid leave, they must continue to take paid sick leave for each day, that's each day, until either the employee uses the full amount of paid sick leave, which is 80 hours, or the qualifying reason for taking the leave goes away. So the Department of Labor, their reason for insisting on full day increments is based on the intent to provide as much paid sick leave as possible to encourage employees to stay home and not spread the virus to others. And later on, Josh will be talking about a minor, well, not a minor, but an exception to the full day leave requirement. So a simple example to illustrate this: if an employee is quarantined by his doctor until his test results come back, let's say he's off for 4 full days, he's used 32 hours of leave. That leaves that employee with an additional 48 hours to use that he must use in full day increments if another qualifying reasons related to the coronavirus comes up before December 31st, 2020. Next slide, please. So as we know from the text of the law itself, it applies to private sector employers with 499 or fewer employees, as well as most public employers. And this is very important. Employees are immediately eligible for the leave, whether they have worked for an employer for 1 year or 1 day. They are immediately eligible. Which employees should be counted? How do you count the employees? The Department of Labor states that employers should count full-time and part-time employees. You count employees that are on leave. You count temporary employees who are jointly employed by the employer in another company. The most common example is if you have a relationship with a temporary employment agency that provides you labor, most likely you're a joint employer and you have to count those employees as well. You also have to count day laborers that are supplied by a temporary agency. Independent contractors are not counted towards your employee requirement, but they need to be true independent contractors. You can't just call an employee and contractor in name only. They have to be true independent contractors. When When do we count these employees? The Department of Labor has made clear that an employee should calculate its total head count each time an employee's leave is to be taken. Each time an employee requests leave, you count your employees. How many do you have? This is obviously an administrative burden. And if we have any employers out there who hover around that 500 employee level, there is the possible dilemma that you'll dip above and below the 500 employee limit at any given time. So for example, if Mike seeks leave on a Monday when the company has 502 employees, he's out of luck, no paid leave. But if a week later, Tara requests leave at a time when the company dips to 498 employees, congratulations, she gets leave. So obviously, this can create some very awkward situations, but this is what the federal government has been telling us. One other note real quickly. What about employers with an ownership interest in another corporation or limited liability partnership or LLC? So these two entities, they're still separate employers unless they are joint employers under wage and hour law. Now, we don't have time today to get into that, but you know, the courts will look at, do you have the power to hire and fire employees? Do you have the power to supervise employees, and so on? So in that situation, you need to consult with your legal counsel, call me, call Josh Gessling, and we can do our best to help you. But if two companies are found to be joint employers, all of those common employees must be counted in determining whether the leave is provided. Let's go on to the next slide, please. Here are some qualifying reasons for leave. For these reasons, you'll pay 100% of the regular rate of pay up to the limits you see at the bottom of the slide, $511 per day, $5,110 total. So $5,110 is the total amount you have to pay. We'll address how to determine the regular rate in a second. So one question that's come up is, can you require documentation from an employee to prove that they have one of these reasons? And in fact, not only should you, but you're required to under the Department of Labor's guidelines. The Department of Labor says that you can, or you must require appropriate documentation identifying the reason for leave, a statement that the employee is unable to work for that reason, and the dates for which leave is requested. This is information the employee must provide to you. And examples of appropriate documentation could be a copy of the governmental quarantine or isolation order. If you look at reason number one, it could be the name of the healthcare provider who has advised the employee to self-quarantine, and the doctor's note. For those of you covered by the regular FMLA, if an employee is taking leave beyond the 2 weeks of paid leave, and they have a serious health condition that is related to the coronavirus, you can still require them to provide the proper and usual medical certifications under the FMLA. Let's go to the next slide, please. More reasons for a paid leave, although for any of these reasons, the employer is only required to pay 2/3 of the regular rate, up to $200 per day, and a total max of $2,000. Josh Gessling is going to be addressing the child care issues. Number 6 is interesting. I haven't seen a lot of guidance on number 6 yet, but I would imagine that if we had a situation, unfortunately, if COVID-19 became COVID-20 or something like that, then I think the government wanted to be able to have some flexibility to have this law cover those kind of situations. Let's talk about the regular rate of pay. For purposes of the Families First legislation, the regular rate of pay is the average of the regular rate over a period of 6 months prior to the date the leave is taken. You don't necessarily look at the last week, you have to look at the last 6 months and take the average. For employees who have not worked for you for 6 months, you take the average rate of pay for each week they've worked for you. If they worked for you for 3 months, you look at the average over the past 3 months. Next slide, please. The amount of hours you have to pay for are capped at 80 hours. These are the hours that are the number of hours the employee would normally be scheduled to work. So for example, if you have an employee who needs 2 weeks of leave and that employee normally works 50 hours a week, for that first week, they are paid 50 hours of paid sick leave. The next week, they would get 30 hours, and then they hit their limit of 80. For part-time employees, what do you do for part-time employees? Part-time employees are entitled to the typical number of hours they work in a 2-week period. So if you have a part-timer that works 20 hours a week, you pay them paid leave of 20 hours. If they work 30 hours a week and they need paid leave for a week, you pay them 30 hours a week. Now, take special note, you have to pay the overtime hours, but not the overtime premium. So in the example that we just talked about the employee who works 50 hours, obviously if they're a non-exempt hourly worker, normally they get overtime for those 10 hours over 40. But you do not have to pay that premium for the Paid Sick Leave Act. You have to pay those hours at the straight time regular rate. Let's talk about the grace period of enforcement. This wouldn't necessarily apply to private causes of action, but until April 18th, the government will not sue you or penalize you for good faith errors in administering these laws, as long as you promise not to do it. And it has to be more than a pinky swear. They're going to make you sign something, but you have to promise in writing not to commit the violation again, and you have to pay the employee anything that they have not been paid. And if you do that, then you're going to probably not be get dinged by the government. That's only until April 18th. There's also a posting requirement. The Department of Labor has published a poster that you need to post in a conspicuous place in your workplace. If you have employees that are working from home, you need to email that notice to them. One other thing I want to mention before I hand it over to Josh, this goes under the category of no good deed goes unpunished. The Department of Labor has confirmed that if you've provided paid leave to your employees before April 1st, That paid leave is not going to count towards the new 80-hour requirement, and it won't be eligible for the tax credits that are available under the law. Just wanted to mention that to you. So I know that's a lot of information in a short time. If you have any questions, please call me. I'd be happy to answer any questions I can. And so with that said, I'd like to hand it over to Josh Gessling, who's going to be talking about the revisions to the Family and Medical Leave Act.
Okay, thank you very much, Mark. Can you hear me?
Yes.
Okay, great. Thanks for joining us this afternoon. I want to talk about the other big elephant in the room, the Emergency Family and Medical Leave Expansion Act. Like the Emergency Paid Sick Leave Act, the Emergency FMLA Expansion Act applies to private employers having fewer than 500 employees in most public agencies. An eligible employee is one who has been employed for at least 30 calendar days by the employer with respect to whom leave is requested. So unlike the law Mark just told you about, where leave is automatically available, to be eligible for emergency FMLA leave, an employee must be employed for 30 days before he or she will be eligible. Slide, please. The FMLA Expansion Act says that eligible employees of covered employers are entitled to up to 12 weeks of job-protected leave for a qualifying need related to a public health emergency. A qualifying need related to a public health emergency is limited to circumstances where an employee cannot work or telework due to a need to care for a minor child when the minor child's school or daycare has been closed or made unavailable for reasons related to COVID-19. Unlike leave under the EPSLA, which Mark told you about, needing leave because the employee has contracted COVID-19, or needing leave to care for another individual who has been advised to self-quarantine or isolate, is not considered a qualifying need under the Emergency FMLA Expansion Act. If you have 50 or more employees, however, it is possible these other reasons could fall under sort of quote-unquote regular FMLA qualifying leave. As Mark also mentioned, leave must generally be taken in full day increments, and that applies to emergency FMLA leave as well. However, the DOL has issued guidance stating that emergency FMLA leave can only be used intermittently for child care reasons, but even then, only with the employer's consent. The record-keeping requirements that Mark discussed apply to emergency FMLA as well. The law permits employers to require that the first 10 days of leave under the emergency FMLA expansion. However, an employee can substitute any accrued paid leave, including the emergency paid sick leave that Mark talked about, if they're eligible. After the first 10 days, emergency FMLA requires that the employer pay employees who have a continuing qualifying need at a rate of 2/3 of the employee's regular pay or rate of pay for the number of hours the employee would have been required to work for the duration of the remaining leave entitlement. Under the FMLA Expansion Act, employers are not required to provide paid leave exceeding $200 per day and $10,000 in the aggregate over the course of the emergency FMLA leave paid 10-week leave period. In the event an employee's work hours vary week to week, the employer must look to the number of hours an employee was scheduled per day over the 6-month period ending on the date on which the employee takes leave. If the employee has not worked for the employer for such a period, the employer must use the number of hours reasonably expect the employee to be scheduled to work at the time of hire. Next slide. Emergency FMLA leave is job protected. This means that generally covered employers must restore eligible employees who take emergency FMLA leave to their prior or equivalent positions. Now, there are limited exceptions for small businesses with fewer than 25 employees who are required to eliminate positions due to operational changes caused by COVID. Specific requirements apply, however, so you'll want to consult counsel or the statute carefully if you plan to try to use this exception to the reinstatement rule. Last, in terms of job protections, these laws also make it unlawful to retaliate against individuals who request or take paid leave protected under the law. Let's talk about a few exclusions. The law also allows employers to exclude employees who are healthcare providers or emergency responders from the emergency FMLA leave entitlement. Unfortunately, the law is a little less than clear as to the outer boundaries of what constitutes a healthcare provider or emergency responder. Instead, it simply refers us to the regular FMLA's definition of healthcare provider, and the FMLA doesn't even define emergency responder. Based on the FMLA's definition of healthcare provider, we know it includes physicians, podiatrists, dentists, clinical psychologists, optometrists, and nurse practitioners. But beyond that, the definition doesn't give us much to work with. We think it's likely, and we're hopeful, that the Department of Labor addresses these definitions through the issuance of additional guidance. Finally, the FMLA Expansion Act also provides a small business exemption for employers having fewer than 50 employees. This exemption is only available if providing emergency FMLA would jeopardize the viability of your business as a going concern. Now, the DOL has not provided further guidance on this yet, but it has said that it will do so soon. If you hope to take advantage of this limited exception, be sure to check the DOL's website for updates often. You can check that at www.dol.gov and stay in touch with your legal counsel in the coming days. I also know that both of our law firms participating today and the Chamber try to provide updates on these types of matters through our websites, so you may wish to consult those resources as well. Next slide, please. Covered employers are required to post a notice informing employees of their rights. This information has been released by the U.S. Department of Labor and is available on its website, again, www.dol.gov. You may download and print this document for free and post it in your break room, share it with your employees electronically, as Mark mentioned. You may also consider updating your employee handbooks to account for these changes to reduce the possibility of confusion. Paid sick leave provided under the FFCRA will not or roll over from 1 year to the next. Employees are not entitled to reimbursement for unused leave upon termination, resignation, retirement, or other separation of employment. Now, be mindful, however, that in Indiana and some other states, the default rule for certain types of other accrued paid leaves is that it must be paid out upon termination unless modified by a written policy or consistently followed practice, with a very strong preference for written policy. As an aside, check your state law and update your handbook to avoid this issue if you've not done so already. That's outside of emergency FMLA leave considerations, but I think something worth mentioning. Now, these leave laws represent significant developments that will impact the day-to-day operations of many small to medium-sized businesses in our community over the course of the next several months. Because of the fast approaching deadline, April 1st, you're encouraged to determine whether these developments affect your business, and if so, take timely steps to implement requirements into your payroll and leave processes. We appreciate your time again, and stay well. I think at this time, I get to turn the stage, the virtual stage, over to my colleague, Jean Blanton.
Good afternoon. We're going to change our topic altogether now and move from expansions to FMLA and paid sick leave and on to the status orders issued by several states, with the focus today primarily being on Indiana's order. Governor Holcomb issued Executive Order 20-08 on March 23rd. The order requires all persons in Indiana when outside of their residences to maintain social distancing from persons, of course, other than their own household family members, and specifically states that Indiana residents may leave their residences only for essential activities, essential governmental functions, or to participate in essential businesses and operations. The order went into effect on Tuesday, March 24th at 11:59 p.m. So the first really full day was the 25th, which was Wednesday, and it ends on Monday, April 6th at 11:59 p.m. But that could be extended if the outbreak warrants it, and that is specifically stated in the executive order, so it's possible this could go on a little longer. The order is mandatory. It is not merely a recommendation. However, you're probably wondering, if it's so mandatory, then why are we not seeing many effects from the order? That is because, one, the essential businesses list is extensive and it's meant to be broad, and that is also stated specifically in the order. But also there appears to be very little risk that there'll be really any type of punishment for failing to abide by the order. So I think many people are able to take liberties with this as well. However, let's start with essential activities, which our focus today is going to be on the essential business list. But essential activities, you're allowed to leave your home for safety and health activities, for necessary supplies and services, for outdoor activity. So you'll see a lot of people out getting fresh air. I think everyone's getting a little tired of being locked in their homes. So I've noticed a lot of people even walking in our neighborhood. Also going to and from work is an essential activity if your work is an essential business, and also to take care of others. So you're not prohibited from going to take care of other family members who may need your assistance. Essential governmental function, which is the second category that is permitted to continue, really are all of those activities you would expect from government. You're the first responders, legislators, judges, court personnel, and it's not just at the state level, but also at the county, city, and town level as well. With respect to businesses, all non-essential business and operations in the state were ordered to cease all activities except for minimum basic operations. If a business does not fall within the definition of essential business and operations, that is then when they're limited to only minimum basic operations. Minimum basic operations does not mean that they cannot have employees on site, however. Minimum basic operations is defined in the executive order to include maintaining the value of the business's inventory, preserving the condition of the physical facilities and equipment, ensuring security, processing payroll and other employee benefits or related functions, and the minimum necessary activities to facilitate employees of the business to be able to continue to work remotely. So in other words, there'll be a certain number of people that need to be on site in order to allow remote access. For example, the one that comes to mind would be any technology staff. But on to what we're probably most interested in, all of us on this webinar today, is the essential business component. One important factor to remember is that essential businesses are not only permitted to continue to stay open, but they're encouraged to do so. And so you might pay close attention when I speak about trying to enforce your employees continuing to come to work in a moment. But first, let's talk about what are the essential businesses as defined by the order. You'll see a list here on the slide. It's non-exhaustive, but you can fit a lot of different businesses in our community within those categories. But the big one that I want to focus on is essential critical infrastructure, because it's even broader than you might think. Next slide, please. The essential critical infrastructure comes from a memorandum that was put together by the U.S. Department of Homeland Security, Cybersecurity, and Infrastructure Security Agency. And each one of these categories that appears on your screen includes a very wide swath of additional categories within each one of those. And so we won't be able to go into extraordinary detail in each of these categories, but you can imagine, looking at this list, that many different businesses will fit within them. And one of the things that is critical, basically, I think, for us all to focus upon is really the businesses that are required to close are places of public amusement or entertainment, or just regular retail shopping that does not include groceries or pharmaceuticals. And so you think of bowling alleys, movie theaters, arcades, museums, zoos, country clubs, things of those nature, they all have to close. And in that regard, there's a lot of businesses that are permitted to stay open. Next slide, please. You've heard a lot of rumors about, I'm sure you have, I have as well, that the National Guard would be out enforcing these orders. Well, we now know after a few days of being under the order that that is not the case. The governor's office has listed, or they have a set of questions and common answers on their webpage connected to the executive order, and they specifically state that the National Guard will not be called upon to enforce the order. What they have stated is that the Indiana State Police will work with local law enforcement to enforce the order. However, they also state that law enforcement will not be stopping drivers while they're on the roadways. They won't be stopping and inquiring where you're going. They won't ask if you're going to the grocery store or if you're traveling for an essential activity or going to work. They won't stop you when you're out taking a walk. And so when I say that there's very little risk of any punishment for failure to follow the order, they've essentially advertised to us that there will not be, other than, it also is specifically stated that there will be enforcement on restaurants and similar bars and things of that nature that are required to only be open for takeout. If they violate the term of the order, then they potentially risk their permits to continue to operate. And so that is something that anyone who is operating a restaurant or bar should be paying particular attention to. Next, I'm sorry, actually go back, my apologies. Let's talk about what is required of an essential business that is staying open. Just because you're an essential business doesn't mean there's not requirements for you to follow to try to keep this pandemic from further spread. We've heard the term social distancing. What we know now, I think everyone knows, social distancing means you basically are to stay approximately 6 feet away from other persons. And that means, employers, that you should be trying to make sure that people within your workforce are permitted to have that space. It's not always possible, but do all you can to do so. Then also, policies should include language that encourages sick employees to stay home. Most employers generally get a little nervous about what type of policies they put in place mandating this type of language. However, under the executive order, there's specific language that states you should encourage those to stay home for at least 7 days after the onset of fever or flu-like symptoms, and 7 days since symptoms first began improving. So that means encourage your employees to stay home for what you're not used to, a little more extended period of time. And you can actually put that out in policies and not run afoul of any other rules at this time because of the pandemic circumstances. You cannot, however, tell an employee that they're not allowed to return until they have a note clearing them from their doctor at this time. The executive order specifically states not to do that, and that is because they are trying to reduce the burden on our medical professionals currently. Many are going to be too busy dealing with the pandemic in order to be seeing patients in regular office hours, and you won't likely get those notes back. So the language says don't be punitive with your employees in that respect. You're also required to allow as many as possible to work remotely. Encourage good hygiene practices, sneeze etiquette, cough etiquette, etc. But also, the order says you should increase and enhance your cleaning practices and your sanitizing practices around especially commonly accessed workspaces, and provide hand sanitizer. We know it's difficult to find it, so soap or water works as well. So make sure you have plenty of that for your employees while they're in the workplace if you are an essential business that is staying open. Next slide. Okay, so one of the challenges I know many are facing is your employees are anxious. They may or may not believe you're an essential business. They think they should be able to stay home. One of the ways that we would encourage you to overcome that challenge is to communicate with your workforce the essential business nature of your particular business. In other words, prepare a communication that specifically defines why you are an essential business under the current order and why the employees are expected to be at work. And that is because we're not only permitted to continue to operate, but we're encouraged to do so by the governor. All right, that covers Indiana's executive order. You will find, if you look, and really you can Google Illinois and Ohio, the executive orders between Indiana, Illinois, and Ohio are very, very similar. And also in effect, Kentucky does not talk about closure of non-essential business, and we don't go through this essential business analysis in the same way, but in effect, it operates the same way. In Kentucky, the governor issued the order on March 22nd. It required all in-person retail businesses that are not life-sustaining to cease in-store operations. So that's the test. Not the businesses that are not life-sustaining were ordered to cease in-store operations. So they include all recreational type businesses or stores as mandatory closures. However, I think you might be surprised what the order defines as life-sustaining businesses. When I went through the list, one that jumped off the page at me was that beer, wine, and liquor stores are considered to be life-sustaining businesses in the state of Kentucky. And at this time, perhaps it's life-sustaining for all of us to get us through this, the stresses of being primarily located at home. That covers the executive order status orders section of the webinar. And at this time, I'd like to turn it over to Mike Schopmeyer from Kahn, Dees, Donovan, and Kahn.
Thank you, Jean. Good afternoon, everyone. The losses that we're facing with this COVID situation are ubiquitous across all industries. Today, we have mostly medium and small businesses on this call, but also notice that we have large businesses. They're going to be impacted because while the legislation that Mark and Josh and Jean discussed, a lot of it's focused on the 50 to 500 employee enterprises. It's going to affect everyone. I know we have people like Kevin Cook and Glenn Muehlbauer on who are with larger industries, but they'll be affected as well because the backbone of America is the industries in 50 to 500. Some have said, and chambers of commerce, of course, will point that out all across the world, that may be as much as 60% of what drives our economies. So you've got to be saying, why in the heck are they picking on us with all these mandates that particularly Mark and Josh cast at us? And the reason for that is because they need those employees to be taken care of. None of us can forget for a moment that it wasn't but a few weeks ago, maybe days ago, that our biggest issue for our chambers of commerce and our economic development agencies was finding people. And now with these acts and legislation, truly our government, state, local, and certainly the federal government are trying to find methods that will help us. So let's turn to the next slide, please. And I'm going to try and dig into some tips that will help soften this blow, these losses that all of us are incurring. The most obvious one, and you're all receiving through various channels, your accountants, your lawyers, chambers of commerce, other business organizations you're involved with, the question of business interruption insurance coverages. I would point out something our Pittsburgh affiliate, Veritas affiliate sent out to us that I dealt so deeply with in the environmental part of our practice back in the late 80s and early 90s. And that is this, remember this, all too often insureds take no for an answer all too quickly. But in certain circumstances, access to coverage may be available. So as I say to people in the environmental area, and we've recovered literally hundreds of millions in the last couple decades in our firm for mainly our manufacturing clients to clean up their sites from prior contamination. If we had taken no back in the 80s and 90s, before the Kiger decision came out, many of our clients would not have recovered, particularly Hoosier companies, all of these funds that have allowed them to grow and expand and put into CapEx. I also want to point out to everyone, remember 9/11, and that a good part of New York City was devoured by a terrorist act. And as you may have read, years and years later, the insurance industry was indeed forced to pay to the Port Authority and others millions and millions, hundreds of millions of dollars out of insurance policies for that recovery. And that will happen with this pandemic as well. So business interruption, I won't go into a lot of detail, It normally applies to losses to your property, but it's going to be broader than that. There's a good article on our website by my partner, Mike DiRienzo. And as I said, there'll be many out there. Your commercial CGL coverages as well. And we'll talk about how we bring those funds in a moment, but that's another source of coverage. Your property coverages, all of us are spending a lot of money doing all kinds of cleaning and other items that we didn't heretofore have to do. We've had added security because some of us have been shut down, particularly non-essential businesses. And so, and all of us, every one of us is going to face a situation where an employee is identified as having been impacted by COVID. It's critical for all of you, this is a sidebar, have your press releases ready. It's going to happen to you. And you can see by what's happened in the media, particularly towards religious institutions. In Arkansas, for example, there's a leopardization taking place towards those institutions for a pandemic on the basis that that's their cause because they chose to worship in Arkansas. So be aware of the bad PR that's forthcoming and be prepared for that. Builder's risk coverage, our construction folks have unique coverages. A lot of us have performance and payment bonds. Within those, there's going to be ability to recover. And some of us have specialized riders, event coverages that are some unique sort of insurances. I'm not by any means, or we're not by any means suggesting this list of the 6 types of coverages are all that you may be able to look to help pay for these losses you're incurring. But nonetheless, I want you to be aware of those. And this is something you're going to have to look to very shortly in the coming weeks, maybe not days, but in the coming weeks and months. Next slide, please. Okay, this is the most important of my 5 slides, or our 5 slides that we put up for you. And this may be one you want to print out and take a piece of Scotch tape and put it up against your wall somewhere. I know all of us are scrambling at this point, cleaning our offices, putting in place procedures, putting out the notices that Mark McAnulty talked about, but you need to find your contracts and insurance policies as quickly as possible. We went through this back in the 80s and the 90s, and we still do it this day, finding old insurance policies to go back when we find environmental cleanups that were from 40, 50 years ago. I'm in the middle of one, or our firm's in the middle of one that goes back to the 40s and 50s in Tell City involving General Electric. And in that case, these old policies may be the source of funds, particularly if, for example, some of these companies, which may and could file bankruptcy as they did in the Great Recession in 2008 and 2009. Consult with your attorneys, your insurance agents. I left off here, obviously, your accountants, and you'll find out why immediately on this process. And all of you are getting webinars and receiving very, very good narratives from those professionals, our colleagues that work in this industry. Notify, 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 and how you do the notice to these contracting parties and insurers is going to be critical. And how that notice is done, you've got to run through the how, what, where, when, and why of how you do that notice. And Tara, can you hear me well? You want to turn your mic on, Tara?
Yeah, I can hear you. I know that there's been a little internet issue, but you sound good right now.
Okay, good.
Uh-huh.
And again, all of this will be on our website. The how, what, when, where, and why of the notice is very critical, and that's where the insurance agents, the attorneys, as well as the accountants are going to come into it. How those notices are sent are everything. You can't just send them an email or make a phone call. That won't do. Within your contracts, within your policies, there's very, very, very detailed methods of doing that. They're going to include probably certified mail, overnight mails, emails, all different methods. When and where do you do it? You have to do it promptly. If you don't do it promptly 2 and 3 years from now, you're not going to be recovering for these losses when other businesses that you compete with and colleagues will be. So this is something to think about and how that's done. For example, many of you have vendors and contracts that are going to be interrupted. You're going to have to document these losses, the disruptions, the delays, and in some cases, the termination or suspension of those contracts. That documentation, I know you don't have time to do because you're trying to figure out how you're going to redo your budgets to survive, but nonetheless, you're going to have to do these notices fairly quickly. As the accountants are telling you, you're going to have to create a COVID loss account. I've created COVID files. Our firm's already doing such. You're going to need to have a separate account that you begin to put these losses into, so that as we begin the claims process, as we begin the contract notification, change order, disruption, ask for additional funds, the additional periods for delay being sought, and potentially terminations and suspensions, we're going to have to be able to document that. Next slide, please. There are, within the Families First Act, there are, again, the good graces of our government that are making the 50 to 500 employee companies work on this. There is within that as well an ability for you to recover, and this includes the self-employed, to be able to uncover funds from your tax filings that you're going to be making. You make periodically to pay the payroll taxes on your employees. And in the context of that, you'll be able to take a straight dollar for dollar credit. And in some cases, next slide, please, you will be able to, you see the limits there, you'll be able to also recover this as well through tax credits that can move forward on future payroll tax obligations. Your accountants, rather than your lawyers, of course, are going to have more detail on this, but those are some of the tax benefits. One more slide, please. And this talks about the guidances are coming down, but you may be able to get a direct refund, for example, if you end up with under these tax credits. And understand, this isn't a deduction, this is a credit. This is a dollar for dollar return that's going to come to you seemingly, in most cases, right away in 2020 in your upcoming filings. So while the government, the federal government's mandated on you a ton of requirements, they've also given these benefits to you in the form of these tax credits. We have about 8 minutes left, and we have we have 4 questions that each of us are going to follow up on. We'll take those in the same order that we've presented to you today. Mark will go first, Josh, Gene, and then myself, and then we will conclude today. So with that, Mark McAnulty, can you answer the first question that was submitted to us?
Yeah, thanks, Mike. We had a question of, can we get clarification on what is considered a federal, state, or local quarantine or isolation order? Is this referring to our current stay in place for Indiana? So that's a great question. It was answered, I believe, pretty conclusively in guidance from the Department of Labor last night. Department of Labor made it pretty clear that the paid leave does not apply to those covered by these sweeping shelter-in-place and business closure orders that are being issued at the state and local levels. under the new law, if an employee is off work because there's no work, then they're not entitled to paid leave, period. And the guidance makes clear that this is the case even if it's a business that closes due to a federal or state or local directive that is not a isolation or quarantine order. I think that is directed at the employee. So that's a good question, and I think the government has made clear that these stay-in-place orders or shelter-in-place orders is not a reason for leave. So great question. If you have any others, please let us know. And I know Josh has a question he's going to answer.
Yeah, thank you, Mark. Can you hear me?
Yes.
Okay, we have another question. Finally, if we are faced with slowing workload, should we furlough layoff workers so they can then file for unemployment and the enhanced benefit? We currently are okay, but it could very well be a cause of need down the road. So I would respond to that by saying laying off employees due to slowing workloads is certainly an option, and just probably somewhat of the unfortunate reality of the times we find ourselves in. Neither the Emergency Paid Sick Leave Act nor the Emergency FMLA Expansion Act would prohibit employers from laying off employees due to a lack of work. That's true whether you do so now or after April 1st, 2020, the effective date. Additionally, Governor Holcomb announced just yesterday that he was suspending the 1-week waiting period before unemployment benefits could be paid to claimants, and this suspension is retroactive to March 8th, 2020. So I hope that helps with your question. Jean, do you have a question as well?
I do. We received several questions concerning specific examples of what are essential businesses and what are not for purposes of evaluating whether or not a business should be open. I hope that you were able to glean answers to most of those questions during my presentation, but for example, someone specifically mentioned tanning beds. I think a lot of people are staying open that clearly do not fall under the essential business category, but again, to be very clear on why I believe there is not a likelihood that we will have enforcement problems. There were two specific questions in the governor's FAQs that are on the Governor Executive Order website, one of which was, what if I think the business I work for should be closed, but they're still asking me to report to work? And the answer was, you may discuss it with your employer. So that suggests to all of us that no one's really monitoring this at all. And so they tell you if you're designated essential by your employer, you should continue to go to work and practice social distancing, and they don't provide any place to contact or any relief to an employee within these materials to even question an employer's opinion as to whether or not they're essential. I think that covers my question. Mike, I'll turn the floor to you if you've got one.
Yes, Jean, I have a question. I have a $12 million invested, or made a $12 million investment in an apartment building that we were to open this spring. Is there any relief for me if we don't get it finished or it does not get rented up and produce income? And there are, I believe, 3 sources that may be available. In the 2008 Great Recession, there was obviously the biggest losses in commercial real estate in our lifetime that I've experienced. And in that case, the reassessments were adjusted and thus property taxes were brought down considerably during that period of time. The other that we've already begun with a lot of our clients and that the banking industry is talking about are lender forbearance loans or instruments where you go in and basically readjust your lending situation. I would also point out that on the Chamber's website, the small business loan program that's been, the new act is out there. We didn't discuss that today. It's covered in detail. Kim Howard at the Chamber and her team are very well versed on that process. It's ramping up, and there may be forgivable loans that are available that you've all heard about. We didn't put that in the program today because the Chamber, I think, has that covered pretty well on their site and with small business. And we would encourage you to give Kim Howard and her team a call. We got a minute to close, and I think a story is appropriate. I have a relative and friend who's a major executive with a Fortune 500 company, and on Kramer the other night as I was driving home on CNBC was talking to him, and that executive was so proud of, and saying how they are giving to their all their employees this paid time off, and went through the periods of time. And I thought it was interesting that, and they employ obviously hundreds of thousands, and it was equal or less than what's being cast on small businesses under the Families First and the CARE Act and other legislation that's been passed on an emergency basis today. So a lot of weight's being put on our shoulders of small businesses. We'll make it through this. Tara, I'm not sure if you have anything else. I see our appointed time is up. So
I think you said it very nicely. I'm going to take just a second to thank all of you for your time, and to thank all the 160 folks that are online, or whatever that number is right now, for paying enough attention to how you help your businesses get through this. If there's anything that's more important in our community right now, I don't know what it is, because our citizens having jobs is probably the most valuable asset to our community. So thank you, everyone, for what you're doing.
Hey, Tara, Mike Schopmeyer, can I interrupt you one time?
Yeah, you can say goodbye and thanks.
Well, you're being very modest. One thing to remember, of course, folks, is continue to support your chambers of commerce, because they're your voice for business and all the legislative changes we need to have made going forward. One, I think, good point of this, we've worked hard on infrastructure in our chambers, and I think you're going to find an infrastructure bill will probably come out of this. Don't you think, Tara? And
I do indeed, yes.
We'll finally finish that bridge between Evansville and Henderson. Thank you.
And thank you all for participating. Stay in close touch and let us know what else you need. Have a good Friday afternoon. You can sign off now.